dear colleagues and friends, dear fellow members of the Faculty of Law and Criminology, dear esteemed guests who've come from afar to join us today, ladies and gentlemen. Indeed, this has got to be the most postponed inaugural lecture ever. I was telling my own students in Kortrijk that I've been here since 2018, and I realized that if postponed much longer, I might just weld permanently to the faculty, a bit like the scaffolding on the Paleis van Justitie in Brussels. Ik ken het huis, je connais la maison. And the reasons for the postponement, of course, are probably known to all, involving a very small virus with rather large consequences, but also some personal reasons, which I'll get to at the acknowledgements. I'm very grateful for the flexibility of our faculty board and the superhuman efforts in particular of our new events officer Isabelle Bergen and our administratief directrice Monique van Dijk and our dean Wouter de Vroe. Acknowledgements will come later, but for now, the law. In choosing the topic of this lecture, I thought about what might appeal, what might work for an audience involving rather distinguished legal scholars, but not necessarily international lawyers, and also members of the public. And I thought it was too tempting. Ultimately, I abandoned the idea to just speak about Ukraine and the situation unfolding there. I also abandoned the idea of working on climate change litigation and the place of scientists in the courtroom, which is an epistemological butterfly I've been chasing lately, but I thought might be not the right topic today. Instead, the topic of my lecture is law in the classroom. I thought I would carve out some thoughts that would also transect our faculty and speak about from the position of a scholar, of an educator, a fellow traveler in the classroom, starting from a very descriptive point. We as legal educators must lead our students through an enormous amount of cognitive and descriptive, positive inquiry and training. My argument is that as legal educators, we bear a very specific responsibility for the manner in which that education is structured and problematized. And I struggle, as I think many colleagues do, with the manner in which we balance the inculcation of legal knowledge with the political, moral, and ethical contexts in which that legal knowledge is set. My dilemma is in asking whether in teaching the law, specifically with international law, do we not internalize a claim in our students that international law betters the world, passing that faith on uncritically to the next generation, and being consciously unaware of the biases, hidden or otherwise, which exist in our system and in our discipline? But more simply, because I know many of you are not international lawyers, I'm sorry for you, but how does one teach the substance of international law with a healthy scholarly distance without falling prey to enduring and tired questions about international law's relevance or character as a legal system? Without reflection on these questions, I posit a process of inculcation takes place subconsciously. The privileged position of the educator, that would be me, at the front of the classroom or producing educational materials, I think creates a need for reflection, a need for ethical practices on teaching and research, practices which are conscious of the power relations that law safeguards, reproduces, and also of the emancipatory potential of the law itself. And this is an enduring conundrum, and this will be the focus of what I say. So why are we thinking about these questions? In some respects, I locate this reflection in the last 3 decades in the postmodern influences percolating throughout other disciplines and fields that have come to shape contemporary legal scholarship. Lessons of from feminism, critical race theory, all right? We'll just take this off. I have a loud voice, it's fine. Oh, all right, I see, okay. I feel like, anyway, it would date me to say which pop star I feel like. So the conundrum arises to a degree from the postmodern influences afflicting or influencing all manner of scholarship. Lessons from feminism and critical race theory, intersectionality, post-structuralism, structuralism, narrative theory, deconstruction. These are legion and manifold, but at their core, all seek to challenge the various ways, the objectivity of knowledge and science, and put forward claims in their most radical postures about the unknowability of truth. And sometimes they call for a more sensitive or relativistic approach to knowledge. To the extent that they converge They challenge the epistemological foundations of knowledge and shake the foundations of science across the humanities, social sciences, and pure sciences alike. Perhaps this faculty, dear colleagues, I'm looking at you, have stood longer as a bastion of enlightenment rationality than most, but we know and we see that those challenges are felt in and outside the classroom. So the core question for me is what to make of it. And for the purpose of my argument, I see at least 3 potential strategies, which, by the way, none of which I endorse. That will come at the end of the argument. But I can see 3 demands that they make on the legal scholar, and in particular, the international law scholar. First, one can take them from a perspective of reform, a broadside against the structural biases of international law scholarship and practice, a cry to identify and to engage with the blind spots of orthodox legal reasoning. We draw attention to the vulnerable, the silent, the marginalized, and call for their participation. We invite others to the table and open the tent. This is rather modest, in fact, and it's different from 2 more radical challenges. The second possibility, and a step towards, and a step away from the law, in a sense, is the methodological challenge. A gauntlet suggesting that not only is scholarship lacking in diverse voices and not accounting for the broad range of human experience, but that this denies law's claim to objectivity, and specifically with reference to international law, our claim to universality. Such methodological demands, if taken seriously, demand more from the scholar than to allow for more diverse voices. They demand a shift in our understanding of the law and legal scholarship themselves, to inquire and question how our methods and tools generate structural bias and privilege certain outcomes. In short, so goes the claim. Law is not normatively inert, but a political instrument that is deployed in service of the status quo. There's an even more radical posture, and of course I'm oversimplifying, but one that goes further than method, and what I loosely would term an ontological challenge. The term ontology I draw from philosophy, of course, is the science of what is, of the kinds and structures of objects. In simple terms, ontology questions the classification and explanation of entities. An ontological challenge to law and legal scholarship does not merely challenge our methods, but the nature of law and legal knowledge itself, suggesting limits to the power of human rationality and logic to make sense and to govern the world we live in. Whereas the methodological challenge puts into question the biases of law itself and suggests that we can have better law in service of better, or at least more transparently expressed values. An ontological critique attacks the foundations of the law as a concept and an object of inquiry itself, and in its most radical postures, problematizes any form of rationality, and with it, takes away the emancipatory potential of the law itself. What is more, in some respects, certain forms of ontological critique can never exist if they're taken seriously and become mainstream. By definition, they are relational, existing outside, and in constant battle with the center, yet never able to join or to supplant it. For to do so would be to embody its own claim to objectivity and to rationality. In some respects, that's all right. Such projects do not offer their own redemptive project. They fixate on the problematic foundations of the here and now. And I find this, even though I don't share that position, I find that restraint to be admirable. It demonstrates an understanding that redemptive projects, always risk of falling prey to their own structural biases, whether unseen or explicit, and can themselves become tools for domination and hegemony. Now, of course, these are caricatures. They're simplifications of the sorts of debates that take place in scholarship, but also in the classroom, in student societies, and affect to a degree, but perhaps marginally, the way that we teach and educate our students about the law. So it's in the spirit of that critical challenge that I wish to excavate the term that we use very often in legal education and practice, but that I think we do not always fully understand, or at least we do not agree with one another as to what we mean. And that term is formalism, not positivism. I think that in many respects the term formalism, sorry, I'm going to change my slide now. I think the term formalism is in many respects a very misunderstood term, and is one of these that stretches across other disciplines as well. We find it in the humanities, we find it in literary criticism and linguistics, aesthetics, philosophy. And at its simplest, Formalism can be defined as a fixation on the form rather than content or substance. But let us be honest, to put it mildly, that's a rather surface-level circular definition. If formalism is about form, I've taught you precisely nothing today. So let's talk about legal formalism as I understand it. And that is an opinion, a provocation, not a statement of fact. But to my mind, I think that the value of the term formalism is to distinguish it from positivism, which I define for this lecture as a concern over the autonomy of legal systems and legal methods, the ability to separate the law from what is not law, the extra-legal. Positivism in law is a normative position about the nature of law. Formalism makes no such claims. Formalism draws on positivism to a degree, and it benefits from the separation of law from other structures and the idea that it is self-contained. But formalism, to my mind, is a fixation not with law's autonomy, but with law's meaning, its interpretation or application. The distinction for the non-lawyers in the room is in the question they pose. The positivist asks, what counts as law and how do we separate it from non-law? The formalist asks, how do we interpret and apply the law correctly? How do we discern what the law means? Now, of course, these terms are deeply intermeshed, and one could argue that they depend on one another, that they're even co-constitutive, but they're not synonyms. Formalism is about objectivism and correctness, and not about legal autonomy, specifically with respect to international lawyers. And I'm aware that many of you are not international lawyers, but hopefully you'll remember Article 38 of the Statute of the International Court of Justice. Whereas positivism would explain to us that this said article is about law's ability to validate its own rules internally, a formalist question is not to question the validity of Article 38, but rather to unpack the categories in it, treaties, customary law, general principles, and whether they're sufficiently elastic. So taken thus, one way to look at formalists is to be constrained by legal forms and structures. A good formalist judge will self-constrain and not let personal convictions or ideological considerations to infringe on their own legal reasoning. No disrespect to the Americans in the room, but I kind of wish we had a formalist judge on the Supreme Court of the United States right now. But of course the question becomes muddied if the positive law opens up interpretative spaces for choice. In international law specifically, this allows for a so-called margin of discretion in human rights courts, the weighing of equitable considerations in maritime delimitation, and of course, proportionality assessments across all fields. These challenge the formalist mind if it is caricatured, because, well, the law may well tolerate a range of permissible outcomes, and reasonable minds may diverge as to these. If formalism is reduced to that rigidity, then it is problematic. And it's not for nothing that taken thus, famous legal scholar and not very noted postmodernist Herbert Hart has termed formalism as a vice. But I would go further than that, and I draw from the scholarship of American Frederick Schauer to give a different sense to formalism, which I think starts to point the way to one of its potential redemptive virtues. Though it is true that a formalist posture might demand an objectivism from law that is not always there, it also suggests the potential for objectivity in the law and beckons to the legal scholar and practitioner to continue to look for that. Moreover, it acts as a constraint against the explosion of politics and power and ideology into the legal space. We may not like what the law says, but legal structures help us to set the limits of what might be acceptable ranges of choices, and in well-functioning legal systems, guide all of us to operate on that same level playing field. If Hans Kelsen is right, and law remains a normative project, in the sense that it is not just an abstract system of rules, but an active project in world-making, in the ordering of society, then it behoves all of us, not just my fellow colleagues in the faculty, but to see the importance that decision makers are guided towards certain outcomes, can contest the foundations for this, but without contesting the idea that we must take certain decisions constrained away from politics, ideology, and power. So in this respect, if I understand formalism in this more redemptive capacity, I think turning to international law more specifically, it raises questions about the nature and the practice of what we do. International law is similar to, but different, and I'll return to this point, to domestic legal systems, in part because of our history, intellectually and otherwise. The proximity of international lawyers to power, at the very least within foreign ministries and international organizations. But more than that, international lawyers often have a sense of anxiety about the fragility of our legal order, about the fragility of our discipline. Is it all not just politics? And especially in situations of crisis where the law is seen to fail, these anxieties tend to place the legal scholar in a defensive posture. I must defend the law as it is before I can go about changing it. Perhaps it is all of these things taken as one, and perhaps it is also, and I'll return to this later, we teach international law in law faculties, where our legal order stands apart, it is different. But I'll return to that nuance later on. Before doing that, I want to turn to two methodological turns in the last decade that have characterized international legal scholarship. And these have, in some respects, tried to inject a new degree of certainty or objectivity in our praxis. Perhaps they are inspirations, perhaps they are competing schools, but there is a continued drive to continue to search for objectivity even in these postmodern times. The first is to look for certainty beyond the discipline through empiricism, drawing from disciplines such as history or economics or sociology to try to recreate the fact basis of law, the real basis of law that the postmodern challenge has brought into question, perhaps irrevocably. But the second one is a rather more structuralist, inward-looking posture, which Finnish legal scholar Martti Koskiniemi, international lawyers will know who I'm talking about, but he calls it a culture of formalism, where instead of looking outside, we respond to the challenges of partisanship, and we try to recreate a position or the possibility of an objective standpoint through which to analyze the law. I'll do these in two parts. So I'll start with what's been broadly described, and I'll focus in particular on the post-1989 re-examination of our discipline, entitled The Turn to History. Francis Fukuyama was wrong. In 1989, we did not witness the end to history. If anything, international lawyers have turned to the past texts, events, and crises, both as a way to understand the root causes which have shaped our present, but also as a professional method for understanding the legal system which we have and correctives for prevailing narratives in scholarship and practice. In this respect, if one is engaged in this turn to history, I think it goes far beyond the idea that lawyers should just look at past texts better. Legal historians have begun to add methodological tools to our toolbox to understand international law both as a structure and as a political project. I'll return to this later. As the liberal multilateralist consensus of the 1990s has collapsed, history has become once more, at least in international law, a site of struggles over the nature and meaning and the proper role of international law. But our engagement with the past, even as we have challenged the role of international law in past events, our reliance on inherited legal concepts and structures, or more precisely, received interpretations of treaties or state practice, has not been merely the importation of historical method. We don't just look at the past better. The turn to history also brings with it a political warning that the errors of the past are susceptible to return. In some respects, to address the history of international law as a discipline has served a double purpose: to challenge our objectivity and our methods, concepts, and institutions, and as a call for the possibility of objectivity through a better examination of those facts that have constituted what we do. There is, at the same time, what Anne Orford calls a hermeneutic of suspicion, and what I call a hermeneutic of hope, of redemption. Suspicion and redemption working together, that the possibility remains that international law and international law scholarship can become methodologically better if we just look outwards. And I would say that much interdisciplinary research in the last 3 decades has been colored by this sense of hope. That the lessons of sociology, of the pure sciences, of anthropology, of economics, lend an empirical basis through which we can ground our truth claims that international lawyers have had anxiety about for at least 30 years, if not far longer. They allow us to accept the postmodern challenge. They allow us to accept concepts of cultural hegemony, of domination, of ideology critique, and yet reassure us by offering us an objective account of the material or social world in which we operate and the root causes for the international legal system that we have today. They remove our uncertainty as scholars, our self-doubt as a discipline, and of course that appeals. What could be wrong with a commitment to rigorous engagement with evidence, careful archival study to get the rules right, the conducting of interviews to understand what people are thinking, the gathering of statistics, far more comforting than a claim about interpreting a treaty? Basically, we all yearn for a degree of reassurance which the postmodern challenge has shaken to its core. I won't go further into this today. I only get 45 minutes, and I tend to speak very quickly as it is. But I wish to focus now and pivot a bit into Koskiniemi's culture of formalism, a rather more internal perspective. This is a concept that I think even the three words, culture of formalism, show us how elastic it is and how difficult it is to reconcile with mainstream approaches. And as you'll see in a moment, his definition of his culture of formalism concept is rather different than the explanation I've given as to my understanding of formalism. In his words, culture of formalism is a culture of resistance to power, a social practice of accountability, openness, and equality, whose status cannot be reduced to a political position by any one of the parties whose claims are treated within it. That does not sound exactly like the formalism that is slightly distinct from legal positivism, now does it? It's because it's a different idea. Koskiniemi does not advocate any embrace of formalism. The clue lies in the word culture, which connotes a sense that formalism is a choice. It is a mindset that rather than deploying the methods of formalism to engage with the law, instead we must understand our engagement with law through instrumentalizing formalism. Formalism becomes an ethical position from which to conduct our inquiry into law and to participate in decision-making in both legal and political processes. It's an understanding and an appreciation of formalism as posture, as a vocabulary, through which we can escape from mechanical managerialism, what he has termed in earlier scholarship, a rejection of the bureaucratic vision of a lawyer as a miserable comforter, grimly executing and discharging their functions according to what the law says, irrespective of its outcomes. If Koskiniemi is right, and the culture of formalism is an ethical position to demand of individuals, then the focus shifts away from the form of international law itself, which perhaps remains an instrument in the service of power, or at the very least, the outcome of processes that have generated power, and the focus turns away from the law and towards international lawyers and the manner in which we engage with our object of inquiry or of practice. The call for a culture of formalism is a call for international lawyers to retain a sensibility that, though shaped and constituted by our background as lawyers, socialized to make a claim of expertise that one can both protect the existing legal system and maybe, just maybe, change it. There's both a freedom in how we do it and a responsibility that we exercise by holding the keys to the toolbox. And here I'll return to this metaphor, but I think the metaphor of a grammarian with respect to language holds true. In the same way that in language a grammarian can reject or validate new trends in usage, the international legal scholar emerges as a gatekeeper. We can resist or help constitute our international law. And here I'm tempted to talk about Ukraine, but I won't. I don't mean in the formal sense of actually making the law. That is too easy an argument to debunk. I'm not talking about the flattering role of la doctrine under Article 38, but I mean in a sociological sense, in a normative and material sense. In this respect, Koskiniemi's culture of formalism, I think, is a tactic. It represents the conscious instrumentalization and the demand that law remain a relevant tool for practice. This takes me to the law in the courtroom. And here, I'll try to broaden the discussion a bit and speak not only to our community of international legal scholars and law professors, but also to the role of law in wider society. And I'll preface what I'm going to say, which is a claim. It's a claim for a sense of responsibility for a sense of responsibility that we hold through the expertise that we've acquired in the workings of the law itself. And I freely admit my stake as an international legal scholar on whom my job depends, as a teacher of international law, as a purveyor of very fine books that we use to teach the next generation. There is something, though, to be said that goes much beyond that. It goes into the intellectual struggles that play out in the classroom, and what we as teachers of international law can do about it. So here's my core argument. I believe that debates about the political, economic, and moral choices behind the law best take place once a degree of socialization, a degree of shared reference points, a building of a common vocabulary can be built. And in the law faculty, this entails a thorough understanding of the object of our study, that is to say, of law, of legal systems. But I also see a conundrum. While imparting the technical vocabulary of the law, of international law, how do we avoid the aula becoming a site for what Michel Foucault calls disciplining, for the reproduction of hierarchies, and the next generation of students becoming a bastion of resistance towards change? Teaching has power. Legal education establishes the grammar, as I've said, and structure of thinking about international law. Through our training and the lessons to the next generation, we delineate the boundaries of relevance. We establish what counts as law and not law, what counts as an acceptable legal argument. Treaty in, Bible out. Simultaneously, though, teaching is a political act. It constitutes the exercise and reproduction of existing modes of thinking of the law and existing choices embedded within the law themselves. And this, in turn, arguably, and that is the anxiety that I'm struggling with, those then are passed along uncritically to the next generation. So there is my question, a question that I don't know if I'll answer today. But is there some sort of centripetal bias in teaching international law? Do we teach it for its own sake? Do we teach it without explaining the purported value system embedded in it, considerations of order or justice or solidarity, which may or may not be ideologically loaded? Is it true that international lawyers have an axiomatic concern about the fragility of our legal system that somehow adds a moral or professional urgency to our craft? So when something like, when I was a young boy, the Iraq War, that dates me, but the Iraq War in 2003 will show the anxiety of the United States engaging in an act of armed aggression against another state with no legal basis was deeply problematic. And in 2022, we experienced the same thing when another permanent member of the Security Council did the same. And explaining that in the classroom, explaining the failure of the system, is in some respects what we must do. And in so doing, do we end up defending the law and apologizing, rather than explaining the root causes of how we got there? So my question, as a legal scholar, is to what extent does that make us responsible for the world that international law has structured in which we inhabit? Are we responsible the moment we step into the aula? I'm not sure. I do not invoke responsibility in the sense of being truly accountable. I do not think our claims to expertise in the study of law require us a fortiori to defend that system or to internalize it. But I do think we hold a discursive responsibility, one that requires us to identify and to reflect upon the social, political, and material aspects of our object of study, even as we teach it, even as we focus on that object of cognition. This requires, to be sure, a step away from a drastically ontological critique. It's rather more modest. Mine is hardly Paulo Freire's pedagogy of the oppressed, a call for critical education that brings structures of oppression to the fore in a political revolutionary project. Even though we might draw certain inspirations from the notion of continuous dialogue in the classroom and students and professors as co-investigators, here I wish to bring an observation based on my own experience, especially in the outbreak of crises. And that experience is rather simple. If we listen to our students, as active learners as they can be, what I've learned in my career as an educator is that they often seek reference points. There's an untranslatable word in French, des balises. They seek vocabularies through which to articulate their political intuitions. And they use the language of law, and they need us to help them to make sense of that. And it is that expertise, to a certain extent, that we offer them. We pass on that vocabulary. And I don't think it is anti-reflexive to point out that it is not that the wider profession demands training in legal proficiency, but also our students themselves. And this is, again, I think a challenge that is particular to international law, but perhaps also spreads across other areas of the legal discipline in the law faculty. But if I can hone in on my own discipline, a little bit of navel-gazing for a moment, international law academics around the world are united by one thing, at least if we teach in the law faculty, and that is to say that unless we receive our students in the first year, we must address students already initiated into the logic of something other, their own domestic legal system. We must undo and yet build on that legal knowledge about a system built differently. And that matters because international law is not just a subject of law. It is an entirely different episteme. It is a different legal order in itself. My law students, despite my best efforts, and yes, I have a civil law degree, so I don't just teach them British common law, don't worry, but my students struggle in the classroom with the difficulties in identifying hierarchy, enforcement mechanisms, legal supremacy. They struggle to identify the apparent differences between international law and their domestic legal system, be they common lawyers, civil lawyers, or from other traditions. They draw analogies to these domestic systems. They're seeking to understand, and they lack that vocabulary. They're perplexed by the very concepts of legal normativity that we try to offer them. And so our toolbox is to help them to understand how international lawyers see the law. And that might be a sociological project, but I do think that it is a first step towards legal change. And yes, we are gatekeepers. But that gatekeeping function matters, not only because of the world in which we live and the place of international law within it, but also because of the demands made in the classroom. So I return to this concept of responsibility, which flows from this professional function. If responsibility is about conversations and social learning, it needs a vocabulary. Legal vocabulary is a useful starting point. The question is how to teach it without teaching it also as the end point. Because an understanding of law, even if radically critical, nevertheless requires us to understand what law is. Those of you who know me know that I might have a critical impulse, but nothing bothers me more than someone claiming to be a lawyer who says, I don't read judgments, I don't like them. I don't read treaties. Treaties are boring. They may be boring, you may not like them, but they are there. And they are powerful. And they shape the world we live in. We ignore them at our peril. And so whatever views we might have about the lack of universality of law, about the fact that it is merely a social construction, about the structural bias that it may have, it is there and it is real. And we, as international legal scholars, as legal scholars more generally, we are its grammarians. We have the expertise and the privilege to be able to disseminate that expertise to the next generation, to what we international lawyers often call the invisible college. The invisible college is a sort of general way to refer to a transnational class of experts who are able to commune in the same language. And there, my dear Dean points very nicely to some of the markers of that invisible college, and one of them is to commune in our great temples of the profession, the Peace Palace, UN headquarters in New York. Others will have their own temples, the Belgian Constitutional Court, the European Court of Human Rights, where the idealized form of the legal practitioner, the legal scholar, the legal expert is embodied, and is the model that we often bring to the next generation. So, for we international lawyers, I argue, we are grammarians and not archaeologists. We do not excavate and find. We interpret and explain, and indirectly have a hand in creating. So our commitment, I think, to international law must break free of a commitment to hold it as a good in itself, and yet at the same time not to abandon it and pretend that it simply doesn't exist. We must detach from both truth and faith. And what I mean by this, let me illustrate this. What I mean by this is that one does not need an emotional attachment to physics to understand the law of gravity. One does not need, I would also argue, a particular emotional attachment to climate science to understand that climate change is caused by human carbon emissions. In some respects, these are facts, and so is the power of law. And I think that rationality and reason can allow us to hold these as true without necessarily making a moral commitment to the desirability of law or to the value of law. In a structuralist sense, then, we are operating not only as grammarians, but we are sensitizing the discipline in a professionally competent manner. We impart that vocabulary as well, and that is the toolbox that we offer our students. The constraints, then, of teaching international law, and this is how I sleep at night, I suppose, but those constraints are the very real tools that we use for our students to be able to exercise their agency. The frames of domination that structure international law may be historically contingent, but they're a powerful descriptive tool that serve both to demonstrate injustice, but also potentially as tools of emancipation. And so in the classroom, to use the memorable words of not a legal scholar, bell hooks, they're a way to teach to transgress, to identify and to move beyond boundaries. The classroom is a bastion of possibility. In that field of possibility, we have the opportunity to make demands of ourselves and our comrades, to open our minds and our hearts to face reality, even as we collectively imagine ways to transgress. So let me bring this to a close. As educators, I believe we must honor our commitment to our students to educate ecumenically, to allow them to assemble the necessary tools beyond scholarship, whether it is to choose a career in practice, to sit the exams of the Foreign Service, or to work in the service of a political cause. I take the view that in teaching, we must accept both the lived reality of international law and an accommodation to those students who wish to understand the state system as it exists. These students are entitled to learn the language of the toolbox through which we operate. We cannot endeavor to train everyone to think like us. We must teach with respect for the differing agendas of our students while robustly maintaining our own scholarly integrity, asserting and bettering our claim to expertise while remaining conscious that the legal systems that we teach are laden with political, moral, and ethical force. The challenge remains how to train students, though. How to train them with that vocabulary and that toolbox, but without somehow along the way forgetting that we're teaching them merely a vocabulary. How, and this is the question that I leave you with, how do we inculcate the vocabulary of technical expertise without unreflexively transmitting to them a sense that the law is unchangeable and that the law is and always should be? How do we teach them to use that newly acquired knowledge to effect change in the world in which we live? That is perhaps something to be discussed outside the classroom, but I will leave you with that thought. Now, I want to conclude with a few acknowledgements, and because I tend to forget people, I'm not like my colleague. I will name very, very few people by name, but I hope you know who you are, and I'm incredibly happy to see so many of you today. Ten eerste, mijn collega's. Dank, hartelijk dank aan mijn collega's die mij warm hebben verwelkomd en opgenomen in deze prachtige faculteit. Jullie openheid en brede blik zijn tot nu een enorme deel van mijn academische reis geweest. Ooit zou ik in deze reden in jullie moedertaal kunnen voeren, en dat is ook het plan. Maar de perfectionistische in mij wilde geen vergissingen maken. Ik ben dankbaar voor het voorrecht om vanuit Leuven aan global scholarship te kunnen werken en omarmd te worden door een intellectuele en onderwijsgemeenschap. Mijn oprechte dank. Back to English. I have to also thank my colleagues and the team of fantastic PhD researchers in the Department of International and European Law, my comfortable nest in this faculty. We have a remarkable community of scholars from Flanders, Belgium, and beyond. They're supportive and collegial. Some have become friends and mentors. Thank you. To my dear friends from outside the university who've joined us today, thank you for taking the time, sometimes traveling long distances. Welcome to the magnificent city and University of Leuven, my new home. I'm very, very proud to share it with you. Finally, my family joined me today. I start with my husband Patrick, by now rather well known in this faculty, spreekt beter Nederlands dan ik. My shoulder, my partner, my best friend. Beste schoonouders, Ruud en Hanneke, bedankt voor het liefde en trouw om zo geduldig mijn Nederlands te corrigeren. We zijn zo blij dat geen Noordzee ligt tussen ons. And to my parents, the reason this lecture's been postponed, who've traveled all the way to Canada, from Canada, I reserve a few words in Spanish, our family language. No encuentro las palabras para expresar el agradecimiento por el cariño, la paciencia y la fuerza que me han conferido. Vivo una magnífica vida y carrera gracias a su apoyo indefatigable. El Atlántico no es que físico y el amor entre nosotros no tiene límite. Les adoro. Gracias. And with that, I draw this to an end before I start crying. Many thanks. Have a wonderful evening.